It's always a bad idea to sign a contract without reading it. That's because a contract is usually binding even on a party who hasn't read it. But this rule can be flexible when fraud is involved, as demonstrated by Park 100 Investors versus Kartes. James and Nancy Kartes were part owners of Kartes Video Communications, known as KVC. When KVC needed more operating space, it leased facilities in the Park 100 industrial complex. Robert Scannell, a Park 100 representative, negotiated the lease with David Kaplan, a KVC senior vice president. Kaplan signed the lease after KVC's attorney approved it. The lease didn't include any provisions for a personal guarantee, and Scannell and Kaplan never discussed one. The Friday evening before KVC was to move into Park 100, Scannell approached the Karteses getting into their car at KVC's offices and told them he had lease papers to be signed before KVC could move into its new space. The Karteses were on their way to their daughter's wedding rehearsal, but Scannell said it couldn't wait. Scannell and the Karteses went into the lobby of KVC's building, where Scannell handed them a document titled Lease Agreement. James called Kaplan and asked, within Scannell's hearing, whether KVC's lawyer had approved the lease agreement. After the phone call, Scannell showed the Karteses where to sign the agreement, and they both signed. Scannell never told them that they were signing a personal guarantee of KVC's lease. Sometime later, the Karteses sold their interest in KVC. After the new owner failed to pay rent, Park 100 sued the Karteses to collect the unpaid amount under the personal guarantee. The trial court ruled for the Karteses. Park 100 appealed to the Indiana Court of Appeals.